Start the live stream. I'm just waiting for confirmation that that has begun. All right, the live stream has begun. So good afternoon and welcome to the Office of Tax Appeals. My name is Judge Long and this is the hearing for the appeal of Mitchell. A hearing reporter, Ms. Alonso, is present and reporting this hearing verbatim. To ensure we have an accurate record, we ask each person speaks one at a time and to avoid speaking over one another. Also, please speak clearly and loudly. When needed, Ms. Alonso or any of our panel members will interject to ensure proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the OTA's website. As a reminder, the Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. While OTA is not a court, we must nevertheless follow certain guidelines to ensure we establish a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Also, I may interrupt if the hearing if we get out of order or become counterproductive, as keeping us on track and creating a clean and efficient hearing record is part of my role as lead administrative law judge. Are there any questions before we go on the record? All right. With that, if panel members and our hearing reporter are all ready to proceed, with that, we are going to go on the record. This is the appeal of Mitchell, OTA case number 240716787. The date is October 7th, 2025, and the time is 1:09 p.m. This hearing is being held in Fresno, California. I am Judge Long. I will be the lead administrative law judge for purposes of this hearing. My co-panelists, Judge Hosey and hearing officer Elsum, and I are equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to identify themselves and who they represent, starting with Franchise Tax Board.
Chris Davis, representing Franchise Tax Board.
All right, thank you. Appellants?
Jackie Zumaida, representing Franchise Tax Board.
Marcus D. Magnus, representing the taxpayers, Robert and Julie Mitchell.
All right, thank you.
Wilfred John McFeeters, Project Management.
And Robert Mitchell.
All right, thank you. Now I'm going to go to the preliminary issues. OTA received appellant's notice of errors regarding the minutes and orders. Thank you for sending that. We are agreed that appellants will provide witness testimony during the hearing. And second, there was a stipulation. It sounds like you may have preferred a more narrow stipulation. I think at this point, unless the parties have prepared a joint stipulation, we're going to move forward with the issue statement as stated in the minutes and orders. All right? All right. With that, as stated in the minutes and orders, the issue to be decided in this appeal is whether appellants are entitled to non-recognition of gain from the sale of real property under Internal Revenue Code Section 1033. Appellants submitted Exhibits 1 through 8. FTB did not object to the admissibility of these exhibits. Therefore, Exhibits 1 through 8 are admitted into evidence. FTB submitted Exhibits A through M at the pre-hearing conference. Appellants did not object to the admissibility of these exhibits. Therefore, Exhibits A through M are admitted into evidence. After the pre-hearing conference, FTB submitted Exhibits N and O. And appellants, do you have any objection to those two exhibits?
No.
All right. With that, Exhibits N and O are now admitted into the record. Let's see. And appellants indicated during the pre-hearing conference that Mr. Mitchell and Mr. McFeeters will be testifying as witnesses. Is that still correct?
That is correct.
Thank you. With that, I'm going to place you both under oath so that we can consider your statements as testimony, and you'll remain under oath throughout this hearing. So I'm going to ask Mr. McFeeters to please raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
All right. And Mr. Mitchell, do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. With that, appellants, you have 1 hour and 55 minutes for your presentation, and you may proceed whenever you're ready.
Thank you. I'm going to open with Mr. Mitchell. Mr. Mitchell, you've already been introduced and you've stated your name. Can you identify the property in question, please, by address?
Yes. I'm going to have to get it, sorry. Oh, okay.
Ms. Alonso, would it be helpful if we had them have two microphones so they can use our microphone during this time, if that's helpful? Yeah. Absolutely.
All right, I'll repeat the question. Can you please identify the property in question by address, please?
Yes, 4974 East Clinton Way in Fresno, California.
And
Get closer. Okay. Sure. Well, now I really hear it. 4974 East Clinton Way in Fresno, California.
now, this piece of property, was it one address for the entire project?
Yes.
The government is arguing that there are three different pieces of property or three different identifiable buildings. Can you explain to me, when you purchased this property, were you purchasing as a whole or were you purchasing it for the individual buildings?
It's one building, and I purchased it as a building.
Was there anything that these three pods or three wings had in common that would identify them as a single building as opposed to separate identifiable buildings? For example, do they have one roof?
Yes. One APN, one address. Is that what you're asking?
Well, yes.
Well, go ahead. I didn't mean to.
Does the project have common area amenities that were shared amongst the entire facility?
Yes.
And what would those common area amenities be?
Primarily the women's and men's bathrooms, upstairs, downstairs, the utilities, water, gas, electricity.
So did all of the utilities come into one location on this property?
Yes.
If you could, please, I've brought a whiteboard. If you could simply draw to the best of your ability, and I'm not asking you to be an artist, but draw to the best of your ability what this structure looked like.
Yes.
And I'm not an artist, so. I'll do this half, all right? This is kind of like a courtyard. That makes sense.
All right, so just so that we can locate, since all of the briefs refer to these pods, or as the government calls them, buildings, as A, B, and C, would you please mark what you understand to be A, B, and C?
So that was mostly for like suites in location of delivery, but this would be A, this would be B, which kind of comes in there, and this would be C.
Okay.
That's not exactly the scale.
Let's draw with a different color if you can. Can you show me, was there a common equipment closet?
Yes.
Where was that located?
So all the utilities were in B right here.
And so utilities came in from the street, that would be power,
Yes,
water?
yes. The meters, everything was there in B.
Were the breaker boxes in that equipment closet?
The main for everything, yes.
What about low voltage communications?
Like AT&T, everything kind of came there because it's one hub coming from the street and dispersed out through the tops of the rafters.
So they went through the connecting portions of the building to pods A and C through B?
Yes.
Okay. Was there a single parking lot for this entire project?
Yes, it's just one parcel, one parking lot.
If repairs need to be done on the roof, how did you access the roof for pods A, B, and C?
You need me to keep writing? Or?
Yeah, well, yeah, just draw it.
I'm sorry, go ahead.
Where would you access the roof if you needed to repair pods A, B, and C or access the HVAC systems?
The main utility area for all janitorial and everything was there by the bathrooms, and it's only roof jack that lifts up, and there's a photo of it that you can lift up. So you access there and you can walk all around all three pods or wings.
Okay. You can have a seat, please.
Sorry, didn't mean to.
Is it possible, without rebuilding A and C, if you were to demolish Part B, for A and C to operate?
No, not effectively. I think we had one small bathroom in A, but all the bathrooms and everything are hubbed into B for the whole complex.
So when you say a small bathroom, was this an ensuite bathroom as part of a TI from an earlier tenant, or was this a common area bathroom that could serve an entire building?
It was just a build out it was pre-existing when I was there, but it was just a small shared bathroom, just inside a suite.
A single toilet
Yes. Single sink, single toilet.
within a
In-
separate office, an identifiable office?
Yes. And there's one in C also, that same way.
Okay. The property was not owned free and clear, was it?
No.
You had a mortgage.
Yes.
Approximately how much did you owe on that mortgage?
The original note was for $2 million, and it depreciated down. I forget what they had down, but it was under $2 million.
Okay. Had you not undertaken the reconstruction of Pod B, would that have allowed the lender to foreclose on the project?
Yeah, I wouldn't have had to. Yes.
After the loss, did you pull new utilities to either A, B, or C?
No.
Okay. When you were evaluating the scope of the loss, was it your intent to reconstruct B?
Yes, 100%. All the bids, everything shows that that was the intention. That's the only intention.
And isn't it true that the only intention to rebuild B is because A and C were worthless without B?
Well, they function together, yes.
Okay.
And it's one building. It's deceiving when it says A, B, and C because it's just suite numbers. But it is one building and one parcel.
So let's put a time frame on this. At the time of the loss, was the entire building leased?
Yes.
How many tenants?
One tenant.
What was the tenant's name?
Hope.
Hope, meaning, if you recall?
I think helping other people in employment. I don't know the exact acronym. I apologize.
But it's a 501c3?
Yes. Yes.
Okay. And when did that lease begin?
February 1st, 2017.
Did that lease require the tenant to reimburse the landlord for property taxes?
Yes, as part of our negotiation, they were responsible for the property taxes. It was a triple net lease.
So were they required to reimburse you for insurance?
Yes.
Were they required to pay rent?
Yes.
How much was the rent initially?
$15,000 per month.
Did the lease require that the tenant pay all costs of maintaining the property
Yes.
and repairing the property?
Yes.
Did the tenant ever pay you a dime?
Because of the timing, no.
So when did the loss occur?
So I believe it's mid-April. It's in the record. So March, maybe 45 days, 60 days after the signing of the lease is when the building collapsed.
So mid-April 2017.
Yes, sorry, 17.
Did you tender the loss to your insurance carrier?
Yes.
How long did the insurance carrier take to adjust the loss?
So in the records, it was like June of 18 because there were so many continued issues. I don't know if you're going to ask me those or volunteer them, but yes, 18. So 15 months.
So
Maybe
15 months,
yes.
There was no rent.
Correct.
Okay. How could, strike that, did Hope continue to occupy any portion of the building after the loss occurred?
Yes.
What did they occupy?
So in the small suite in A, where the one bathroom is where they were at. And at that time, I think they had 3 employees. The records, it should state that, how many employees they had, 3.
Okay, so there were 3 people occupying
Yes.
a 33,000 square foot building,
Correct.
and they paid no rent.
Correct.
Why did you let them stay in a suite within Pod A if they weren't paying rent?
Well, initially, I thought we would be rebuilding. You're just working with them and trying to cooperate. They were there for 45 days and it collapsed. It wasn't their fault. But eventually, it was to protect the building, too, because you have a vulnerable building that was collapsed. And so I felt them being there would be an advantage.
In the area where the building is located, has there been a history of vagrants moving into vacant buildings?
Yes.
And had vagrants been setting fires within these buildings?
Yes.
And had vagrants been stripping the buildings of anything valuable?
Yes.
Did your efforts to prevent vagrants from moving into the building work by keeping Hope at least in one suite?
No.
What happened?
So in part of the claim, you'll see that a lot of the copper wiring, all 3 air conditioning units were salvaged and damaged. And so they were just taking anything that they could take.
How did the vagrants access, well, strike that, where were the HVAC units located?
So in each wing of the building, there was a air conditioning unit on each wing.
And how did those vagrants access those HVAC units?
So as the roof collapsed, so what would happen is we had a big storm. It was a hailstorm and rainstorm, and the hail clogged the drain and overflow. So there was so much rain, and there's pictures, I think, in the records. It was like 18 inches of water. The roof just collapsed because the drain was clogged. So half of that building just fell down on top of, and as it fell down, it left kind of a place that they could climb up and get around. And they're just scavenging anything they can get, but that was at risk all the time. It's not just unique there. I'm sure you've heard stories that there's, mostly copper. It seems to be the hot item there. Sorry, go ahead.
So did the vagrants simply open up the units and take the copper, or did they do something else?
No, they went through the rafters, they pulled wire everywhere they could pull it, but you just don't know what's happening at the time.
Isn't it true that the vagrants took the entire HVAC system, the units, off and threw them to the ground?
Yes, that is true.
So how is it that Hope, having 3 or 4 employees in one suite in Pod A, somehow were able to continue to occupy that suite in Fresno, California with no HVAC?
So they had a little portable air conditioning unit that they just took the rubber vent and just put it in exterior venting is how they kept it cool.
So they cut into the ceiling of A in order to put the HVAC?
Well, the return vents, they just went it up there.
Had you had a conversation with them about it becoming just a month-to-month and tenancy at that point?
Pretty much the lease terminated because their main function and use was the training center, because they were building it to help people get employment and train them. Sorry, go ahead.
Where was the training center going to be located?
It was located in B and C, but
Okay. And at any point, did the insurance company did they send anybody out to determine how much it would cost to repair the property?
multiple times.
And were you unsatisfied with the bids they were getting?
Yes, that's why it took so long.
Did you have an engineer look at the property?
Yes.
Were the walls still plumb on the exterior of Pod B?
No, hard to describe, but there's a main beam that holds up the whole second floor on the first floor, and when the roof collapsed, that whole beam was damaged, but it also lifted that beam up through the whole complex, and the exterior windows all broke in that complex, and there was damage all around. And I think there's pictures of that shows everything had to be boarded up, and but it was damaged throughout.
Isn't it true that they were bowing outward?
Multiple inches.
Were there discussions with the engineers about whether that could be salvaged or if it had to be completely destroyed and rebuilt?
That was kind of the debate of what would be the best way to proceed.
What was ultimately decided as the likely way to proceed?
The likely, because of the unknown part of the damage, and I think we had different bids, would be to potentially totally demolish it and come back from scratch to rebuild it because of the damage of the walls, the beam, the structure.
And was that a risk analysis determining that if you tried to salvage it and you determined you couldn't, you'd have to incur the same cost twice?
And those bids are in there, but yes, because you don't know until you dig into it what you're dealing with when you're talking about a structural beam.
Okay. I'm going to hand you what has been marked as Appellant's Exhibit Number 1. Can you identify that document?
Yes.
What is that document?
This was one of the bids that we received, and I see it says June of 2017, so fairly early on, to demolish and replace the building from Curing, which is an outside company.
Okay. And Querying was an outside company that provided a bid, correct?
Yes.
How much did they bid to prepare the work in June of 2017?
I think it's included in evidence, so you have it, but it's 1.990, 184, just under $2 million.
And would the scope of work that they included in their build have replaced the Building B exactly as it was before the loss?
No.
What would it not have covered?
So in a lot of insurance policies, you don't realize it until you have a claim, but there's caps on what they'll cover, like code improvements. So there was code work that they capped out. So all the codes for fire and sprinkler, because the whole complex had no fire and sprinkler in it because of its age. But as you rebuild and pull permits, then you're required to upgrade to the whole building. So we had also information on that. There was also an exclusion for any hazardous waste. So we got another bid from another company that showed that there was asbestos and hazardous waste, there was mold, and to remove that was another bid, which was, I think, $250,000. That's included in evidence that was kind of unknown, and then ADA upgrades that you'd have to do in the complex as a whole, because anytime you're doing something new, they require you to bring it up to code.
Okay. So I'm going to hand you Appellant's Exhibit Number 2. Can you identify this document?
Yes.
And what does that document represent?
As you see, scope of work, it says asbestos and mold abatement, selective demolition. So this was selective just to take down some of the areas, not a full demo, just to see what kind of additional problem. And then they discovered, as you see, it's in the roof, all the roofing, all the flooring, not including the mold because all the rain came down through the whole complex.
And their bid was?
For that portion, $176,000.
Okay. Let's hand you Appellant's Exhibit Number 3. Can you identify that document?
Yes.
What is that document?
This was another bid or secondary bid to compare to Curing's bid. And it was to selectively look at some of the demo and repair and then overall replacement.
So there are two numbers. The selective demolition, if they were to come in and selectively demo, that was going to cost $325,000, correct?
That is correct.
And if they determined after that selective demo that they could not salvage the building, you would have to incur an additional $255,000 to demolish the building?
Correct.
Or you could decide to simply demolish the building and save the $325,000?
Yes.
Okay. Did Bernard's also provide a bid or an estimate of what it would cost to rebuild Building B?
Yes.
And what was the amount or the range that they provided?
Again, it's in evidence, but the range here is $175 to $225 per foot to rebuild it.
And how many leasable square feet were in Building B?
I think that their bid or somewhere showed was just under 10,000 feet.
Okay. So if I were to take that number and multiply it by the 175 or the 225, that would be their estimated cost or the range of what it would cost to rebuild.
To rebuild, but not tear down and demo. But yes, go ahead.
Okay. And so if my math is correct, based on the 9,300 square feet that Queerings had in their estimate, 9,300 times the 225 gives you a $2,092,500 number. Is that math correct?
I'll take your word for it.
So their total bid on the high side would have been the 255 plus the $2,092,500.
Yes, the cost to demo it, then to rebuild it.
So just to
And that also excluded environmental, so I still would have the environmental side. Every time I look, you
right.
get close.
And just to be fair, if we landed on the low side, it would have been 175 times the same 9,300, which would put you about $1,625,000, right?
I believe so. I trust your math.
Okay. Now, as the property owner, how many, you already stated how many months had elapsed since the loss. Were you still incurring costs of ownership of the property?
Yes.
What were you incurring?
Well, the mortgage payment's obvious, so that was consistent. I think that's also an evidence the state has. Normal insurance that we continued to pay.
How much were your mortgage payments?
The mortgage payment was $10,000 per month.
And how much was your annual insurance costs?
What I have down here in my notes was about $12,000 per year.
Per year? Okay.
Yes.
And property taxes?
I believe it was a little bit north of $24,000 per year.
Okay. So you are negative cash flowing throughout this period of time. You're losing money.
Yes.
Was it in your interest to get the property back reconstructed and relet?
Absolutely.
Why didn't you lease any portion of parts A and C during this period?
As I previously said, because without the bathrooms and everything for a common area, it's impossible to lease the other part of the buildings. the one space that they were using had a small bathroom, but it wasn't for the public. So it was impossible for me to lease any buildings without bathrooms or air conditionings.
When you undertook reconstruction, would you have had to cut the power to the whole project?
Well, because all the power comes into one source, and that is the building that collapsed, yes.
So there would have been no power for the period during which Building B was reconstructed.
Correct.
Isn't it true that had you attempted to let it and then you tried to rebuild it, you would have ended up in breach of contract to your new tenants?
Sure. If you got to demo a building right out your window and rebuild it, then it would be very difficult for me to lease or retain them.
Did you attempt to determine how much it would cost to install fire sprinklers in the project?
Yes, because I was informed that not only do you have to put them in the T-bar like you see them here, but you also have to put them in the attic, and then you also have to put them in the overhang all the way around on the exterior and then exterior attic, because all the walkways, so it was substantially more than I thought as far as the total.
And what do you recall what the total cost was?
And I have notes down here, but it was over $150,000 or more. I just put plus for the fire sprinklers because everything has to come in an existing structure to get up and get in there and do it. So everything has to kind of be removed in order to put it up and then replaced.
And when you're talking about removing, you're talking about doing building parts A and C, correct?
Correct, because the code upgrade required me to do the building, which it is one building looked at. It's a city APN, so I would be required not to just do quote-unquote one wing. They're saying that I'd have to upgrade the whole building.
Now, you testified earlier that the HVAC units for the entire building were gone. They were stolen.
Yes,
Did you get a bid to replace all of those?
we did, and I think part of the bid, even the numbers I came up with existing and some of the bids from B was in there, and I think it was $50,000 just for the B, but then it would also include A and C, or those wings of that part of the building.
Okay.
So $150,000.
Another $150,000.
Yes.
Ultimately, did you settle with the insurance company?
Yes.
And what did the insurance company pay in total?
The total payment was, and I don't have it in front of me, but 1.7 something. I think the state has it in the
So
the
about
evidence.
$1.7 million, correct?
That's correct.
Was the $1.7 million going to allow you to rebuild buildings B, or Part B, as well as reconstruct A and C with the damage caused there?
No.
Did you make a determination of approximately how much extra money it would take to get the project back where it was before the loss?
The best you could, because there's the variable with asbestos and removals and how that goes, but I think, I had numbers of like close to $1 million additional cost of each of those items that I've discussed that were excluded from the bids and excluded from the insurance payment because I was capped on any of the improvements. And that doesn't include the lost revenue. It did include some of the payments that I was going to have to continue paying as it was being rebuilt. So I don't know if you need that or wanting that with or without the payments, but yes.
Did you happen to have $1 million laying around that you could put into a building or a project?
No.
Did you go to a bank and ask to finance that work?
I did talk to my banker, and under the current condition, and I had a first trust deed already. There wasn't a sufficient amount of value in its current conditioning or that it was permittable at that time. So they said it wasn't a project they'd be interested in.
So the loan-to-value ratio was already too low.
Yeah, in the current damaged position.
Particularly if they were going to take a second priority deed.
Yes.
Did you ever run the numbers to determine if the project were rebuilt, whether the cash flow from the rent would even cover the mortgage payment with the second deed of trust?
Well, in that I knew the amount that I was getting in the lease. I knew it was deficient because I'd have to go get another loan on top of my existing loan, and it was barely covering as it was. So
So it was uneconomic.
not it clearly.
How long after you got the bids did you get your final payment from the insurance company?
Well, the one I was June, and the insurance payment, that was June of 2017, and the final payment in the insurance was June of 2018. Again, I believe that's all in the records. So
Were you-
about a year later.
Were you following what was happening in the construction industry in the Fresno area between 2017 and 2018?
Yeah, like a lot of areas, there was a lot more demand than there was supply. And so it was hard to get people to even give me bids. And so construction costs continued to escalate. And I think we did communicate that to the state, that these costs were potentially even higher.
Isn't it true that you spoke with one of the contractors that submitted a bid, and they said that those numbers were out of date?
Yeah, because it was a year later. And they just said that bid is no longer, it was 90-day valid, and it's past that time, and everything's changed. So I knew it was going to be higher than even what we've used here as examples, factual information.
So the $1 million deficiency approximately would have been greater.
Absolutely.
When you sold the project, did you sell it because it could no longer be economically rebuilt?
Yes, and reduced the price accordingly.
What did you sell the project for?
$2 million.
Did you receive any cash on that sale?
No, it was strictly a note. It was to Hope, which is the nonprofit, and it was interest only and no money down. Actually, I think the state has that I gave them money to try to help them with their air conditionings, and what their intention, and I don't mean to get ahead of anything that you're going to ask me, but their intention was evaluate, see if construction would be some of their training strategies for their training. So go ahead. I didn't mean to keep.
That's all right. And did you take the proceeds, that note, and assign it in a 1033 exchange for a property of consistent use?
I did. And even in the purchase agreement, both the sales agreement and the purchase agreement of the replacement property, it's clearly stated, both were aware that it was a 1033, that exchange was coming over, and they pre-approved the note, that they were accepting that as part of the exchange.
By they, you mean the seller of the replacement property pre-approved the note as
That's
part of the
correct.
consideration?
Yes.
Were
And
you-
that's also so a lot of this is in the state's evidence that's highlighted, so it's there, but it's in the state side, so it is there.
Were you required to personally guarantee Hope's note to the seller of the replacement property?
I was, to have that as terms to have the seller comfortable to receive that as part of the exchange. I had to personally guarantee it.
Are you familiar with 1031 exchanges?
Yes.
Isn't it true that you have engaged in multiple 1031 exchanges in the past?
Yes, and
And
Sorry.
isn't it true that you also had another property that you did a 1031 exchange into the same replacement property?
yes. Which 1031, clear, 1033, both of them were exchanged.
Had you believed that you needed to do something other than treat this as a 1033, you could have easily done a 1031, correct?
Absolutely.
And
Because
you would have had you believed it to be other than a loss because of the
I
the
took a note,
rain.
took no money.
Please
Oh,
wait until each
Okay.
question or answer is finished.
okay.
So I'll repeat my question. Had you believed that the sale was caused by any reason other than the damage caused by the rain, you would have done a 1031.
Absolutely.
I've got no further questions of this witness.
All right, thank you. We'll hold questions until both witnesses have testified. So we'll go ahead and let you start with your second witness, please.
Do you want the state to ask questions of this witness, or how do you want to proceed?
I had planned to hold questions until after both witnesses had testified, and it looks like Franchise Tax Board's in agreement with that.
That's
so we'll
fine.
go ahead and have Mr. McFeeters testify, please. Thank
All right,
you.
Mr. McFeeters, you've been sworn. Can you please state your full name for the record?
Yeah, Wilfred John McFeeters.
And are you currently employed?
Yes, I'm semi-retired.
Do you have a company?
I have a company, yes.
What is the name of your company?
Wilfred John McFeeters and Associates.
And what do you do in that business?
I provide project management, real estate strategies.
What was your training in real estate?
I've done lease and brokerage with Fortune 100 companies for what they call corporate real estate.
Have you provided construction management services in the past?
Yes, in construction management is mostly from large architectural firms on the architect side.
And isn't it true that you also were trained as an architect?
Trained as an architect, yes.
And when were you hired by Mr. Mitchell?
During the early stages of 2017.
I'm going to go back to exhibit number 1. Can you identify to whom that bid was submitted?
Yes, Querying Engineering.
And who was it sent to? Who is the name of the client?
Will McFeeters, me.
So was it your job to seek or solicit bids to determine what it would take to reconstruct the
Yes.
damage?
Yes.
And you solicited bids from, among others, Bernard's and Querying, correct?
Yes.
And
Also, the Bowen, but the Bowen was under me too for the asbestos and demo.
Okay. As part of your assignment, did you actually go to the project, to the site?
Yes, I saw the site.
Did you observe the buildings or the building within the project?
Yes, it's quite dangerous, so I didn't go too far into it. All of the trusses had collapsed.
And this is Part B, correct?
Yes, Part B.
Did you go into Parts A and C as well?
No.
Okay. Did you determine that, or did you make any recommendations about whether the building should be destroyed or attempt to salvage it?
Yes, I mean, you took a look at the damage, and you have to say, well, you can't really make a determination on partial reconstruction because you'd have to get through to see what's really happening. The trusses collapsed, the outside windows bowed, there was water damage throughout, there was mold. It's really pretty disastrous.
So when you say you have to get through it, are you saying you have to go into the building itself, remove the drywall to get to the structure?
Yes, there is partial demo to even determine your costs of rebuild.
And that were bids submitted to do that partial demolition?
We determined that instead of partial demolition, it would cost way more to do that. It's better just to rebuild a new building at that point within the building A, or B,
Okay.
where the damage was done. It was better just to rebuild the whole thing rather than try to do partial because that would cost a lot more.
And your recommendation was then,
Yeah, let's get bids to rebuild Building B, and that's what these are,
okay.
along with demo and asbestos.
So as a project manager in 2017, 2018, were you familiar with what was happening in the building industry in Fresno at that time?
Yes, construction was high, lumber was really high, highest we've ever seen it during that time, and so it was difficult to get bids, but we managed to get some, and they could only hold them for so long because of costs were even going up. So
So Were you aware that Mr. Mitchell received an insurance settlement in June of 2017?
No, that really wasn't part of my scope, so no, I don't.
So your scope ended after you solicited the bids, you got the bids, and then you gave your recommendation to Mr. Mitchell?
Yes.
Thank you. No further questions.
All right, thank you. FTB, do you have questions for either witness?
Oh, you need a mic.
All right. Please return FTB's microphone. All right. Here you go. Please go ahead and begin when you're ready.
Actually, can I just take one moment to confer with co-counsel?
Of course, please go ahead.
Respondent has no questions for witnesses.
For either witness?
Either witness, correct.
All right. I'm going to turn to my co-panelists and ask if either have any questions. I'll begin with Hearing Officer Elsom. Do you have any questions for either witness?
I do have a couple questions. And I'd just like to start with a little bit of the history behind this property and with your respect to your intent with holding the property.
Yes.
Can you explain why the exchange was originally reported as a 1031 exchange? And I know you'd mentioned that if you'd wanted to do a 1031 exchange, you could have. And then at the time that you signed the lease agreement for this property, did the potential sale of the Clinton property factor in your plans to purchase the Monterey property, which you eventually exchanged into?
So first question, and it is filed in the tax return as an exchange. I think there might have been some confusion with the bookkeeper as far as saying 1033 or 1031 are the proper definitions of it. But all the information from my purchase agreements and everything that I forward to the state, emails, text, even to the bookkeeper, it was 1033. And I think they agreed to that early on, that they agreed that portion, and I think that's why they proceeded and allowed the insurance to move over, but decided that the building we're going to treat differently. But it was all in there that way. The second part with your question as far as the building, they had the intention to purchase, and there was a purchase agreement in the lease, or an option to purchase, and that was at $3.3 million. But this was like 15 months later, and the garden or the Monterey property wasn't even being considered at all, because that was on another exchange, and if you are familiar with the 1031, you only have a small window to identify and 180 days to complete. My understanding in the 1033 is that you didn't have to use an accommodator. You have 2 years to do it. You still have to do it with like-type property, and you had to roll over all the money. And in the state's information, you'll see that even in the escrow instructions, it actually notes, or excuse me, the closing statement has the total amount of insurance proceeds in there and the total amount of the sale. And I understood that that was a note, and it was a $2 million note, and that was exchanged over. And actually, I never even took constructive receipt of it because it went from one escrow company to the other escrow company. So if it was, when in retrospect, if the argument was that it wasn't 1033, I would have said I could have easily paid an accommodator to hold that note for, I think it was, don't hold me exactly, but I think it was less than 30 or 40 days. That transaction happened that fast. So it wasn't like I held it, collected money from it, had any intent to do anything incorrectly. My intent 100% all along was that it was 1033. And so the information that was submitted to the state early on, not to the investigators or what it would have been, showed text, emails, all the intent all the way through.
Okay, thank you. And just to follow up, this note, it was 5 years, it was interest only, and you had guaranteed the note. Was that note fully paid by the obligor?
So what because it was a nonprofit, and you can see, it's not in evidence, but I have, that the city of Fresno, the state, and California Endowment provided $800,000 capital project. The Community Foundation of Central Valley, California gave them $200,000, and the city council president, Tyler Maxwell, gave them $500,000. And they're working with them to do the project because it was good for the community. It was good for, to train. I mean, their intention is perfect and honorable and what we need, but I think it was paid, and it was paid with grants and donations from multiple, I guess you would say grants or 501c donations.
Okay, thank you. That's very helpful. Second question, again, I want to continue with the lease negotiations with Hope. Can you just provide a little more detail regarding the purchase option, why that was included in the lease agreement, and if you had any discussions about renewal terms? I believe it went month to month after the lease was.
Yeah, that was in there because their long-term intent was to purchase. And I wasn't opposed for them to purchase it. We had a price of 3.3. After the damage, I sold it for 2 because I discounted it exactly the same ratio. And even though I received 1.7, that 1.7 just made me whole on loss of rent, the taxes I've paid. So the net, there was no profit in it. They benefited because they purchased the property for $2 million instead of 3.3. The intention was they were hoping to do that, but they started with 3 employees. They had great aspirations, but they had support of the mayor. They had a lot of support within the community to be positive, and so I was open to it.
Okay, thank you. And then last question, you've got a great diagram here, but
when I look, it doesn't look so good. Sorry. I know it's live stream, so.
Just purely for context, can you provide or maybe explain some of the prior tenants that leased this property and how Pod B factored into that, or how it was used?
Yeah, so in Pod B, it was a large, and I was involved in that at the same time, and it was a large open, like a mortgage processing thing, so it was a large open space. She looked at it as an opportunity it was a large training room, and that's what her structure and goal was. So it was a large open space that had cubicles in it, but when the roof collapsed, all the computers, and that was part of the claim, because that was still my property. At that time, it was only 40 days that they'd been in there. Unfortunately, it was terrible timing for them, and for obviously for me, but it was a large open area, and so I was occupying it jointly, and but that was shortly after 2008, because it was mortgage process, everything collapsed, so it had been vacant for a long time. I think the state even quotes in there that there was negative, I think something said to the effect that I had negative losses previous to that in my tax return, so you'll see that it wasn't a profitable situation with a lot of tenants.
Okay, and were there customers coming in, or use of that? It was just mortgage.
When they stay, or no, it was just an outbound.
Let him finish his question.
Sorry.
That's okay. Go ahead and just explain how.
No customers came in that particular situation. It was an incoming telemarketing or incoming processing center.
Okay, thank you.
Sorry.
All right, Hearing Officer Ellison, does that conclude your questions?
Sorry, no further questions.
All right, thank you. Judge Hosey, do you have any questions?
No questions from me. Thank you both for your time today. I appreciate your testimony.
Thank you.
I also have no questions for either of you. Thank you for your testimony. Mr. Magnus, would you like to continue your presentation?
I think I will conclude simply by giving some closing arguments.
Absolutely. You are welcome to do that, or you can wait until after Franchise Tax Board's presentation and then include all your time in your rebuttal.
I'll reserve that.
All right. With that, we're going to go ahead and take a 10-minute recess. The time is 12:02. We're going to return at, 2:12. Oh, sure. Okay, in that case, we'll go ahead and continue. FTB, do you need a break before we go to your presentation? All right, FTB, you may begin whenever you're ready.
Good afternoon. I am Chris Davis, representing Respondent Franchise Tax Board, and I'm here with my co-counsel, Jacqueline Zumeta. The issue in this case is whether appellants are entitled to defer the recognition of a capital gain of roughly $2 million as an involuntary conversion under Internal Revenue Code Section 1033. During 2017 and 2018, Mr. Mitchell, one of the appellants, owned a piece of real estate referred to as the Clinton property. The Clinton property consisted of 3 interconnected buildings referred to as Building A, Building B, and Building C. These These were the names used by the taxpayer, as we can see in appellant's opening brief, where they mentioned that those are the terms used by the taxpayer for those buildings. In January 2017, Mr. Mitchell leased the entire Clinton property to a charitable organisation known as Hope on a 5-year lease, under which Hope agreed to pay Mr. Mitchell $15,000 a month and to reimburse Mr. Mitchell for certain expenses, such as property taxes, insurance, and operating costs. Hope also agreed to make improvements to the Clinton property to bring it in line with modern building codes, such as installing an elevator. In April 2017, the Clinton property flooded following a storm. All 3 buildings were damaged, although Building B was damaged most severely. Respondent understands that Hope continued to operate out of Buildings A and C, but vacated Building B. Appellants have acknowledged this understanding in its opening brief and its reply briefs, and has never claimed that Hope only operated out of Building A until Mr. Mitchell's testimony today. Mr. Mitchell chose to let Hope occupy the Clinton property rent-free following the storm damage, hoping that this would deter thieves. It is not clear from the record whether this constituted a new lease or an amendment of the existing lease. Mr. Mitchell received roughly $1.75 million in insurance proceeds for the damage to the Clinton property. In 2018, Mr. Mitchell sold the Clinton property to Hope for $2 million and used the proceeds to acquire the Garden Road property for $10 million. Following an audit of appellant's 2018 tax year, respondent determined that appellants had a casualty gain on the receipt of the insurance proceeds and a capital gain on the sale of the Clinton property to Hope. The calculation of the casualty gain is shown in Exhibit O and is the insurance proceeds received less 1/3 of the basis as provided by appellants. And the casualty gain was $1,230,627. And respondent did not include this gain in appellant's taxable income, and it's not a subject of this appeal. Respondent then calculated the capital gain on the sale of the Clinton property to Hope. Respondent calculated the gain as being the sale proceeds of $2 million, less the remaining adjusted basis not used in the calculation of the casualty gain, being $1,042,306, for a taxable gain of $957,694. And respondent included this gain in appellant's taxable income as seen in Exhibit N. The burden of proof is on appellants to prove that respondent was incorrect in its assessment of additional tax. In general, taxpayers must recognise a gain on the sale of property in the year in which that gain is realised. Under Section 1033, a taxpayer may defer a gain when the property is compulsorily or involuntarily converted as the result of destruction into similar property within 2 years of the end of the taxable year in which the gain is realised. In limited circumstances, property that has not been destroyed may be sold alongside destroyed property, and the gain may still qualify for non-recognition treatment under Section 1033. The tax court in the case of Massa versus Commissioner laid out a 4-part test to determine whether non-destroyed property may be sold alongside destroyed property and still qualify for non-recognition treatment. First, all the sold property must have been used in taxpayers' business together as one economic unit. Second, a piece of the property must have been involuntarily sold. Third, continuation of the business on the non-destroyed property must have been impractical. And finally, the proceeds must be reinvested in similar property. appellants must meet all 4 of the requirements. Failing any requirement means that the transaction does not qualify for gain deferral under Internal Revenue Code section 1033. In this appeal, appellants and respondent agree that the final requirement was satisfied by Mr. Mitchell's purchase of the Garden Road property for $10 million. However, the appellants have not met their burden of proof to show that the other 3 requirements were satisfied. Starting with the first requirement, all of the sold property must have been used together in Mr. Mitchell's leasing business as an economic unit. In Revenue Ruling 78-377, the Internal Revenue Service defined an economic unit as existing when there is a substantial economic relationship between the destroyed property and the non-destroyed property. A substantial economic relationship exists when the non-destroyed property could not have been used without the destroyed property. The case of Massa versus Commissioner provides a good example of an economic unit. In Massa, the tax court held that a loading building and an adjacent parking lot were one economic unit because the parking lot was essential to the operation of the business. Appellants insist that the Clinton property was an economic unit because it was one piece of real estate, and according to them, the 3 buildings could not be sold separately. However, that is not the test of an economic unit. Rather, the test requires an examination of whether the non-destroyed property could have practically been used without the destroyed property. Here, it is clear that buildings A and C, i.e. the non-destroyed property, could have been used without building B, the destroyed property, because buildings A and C were, in fact, used without the destroyed property. Mr. Mitchell continued leasing buildings A and C to Hope after the flooding, and Hope continued operating out of those buildings. Appellants place undue focus on the fact that Hope did not pay Mr. Mitchell rent after the flooding. This argument is misplaced. Mr. Mitchell chose to let Hope operate out of the property rent-free after the flooding. The fact that Mr. Mitchell did not charge Hope rent does not mean that buildings A and C did not continue to be used in his rental business. In fact, appellant's own tax return supports this analysis. Appellants claimed expenses related to their leasing business for the Clinton property on their 2018 tax return. This proves that they considered the leasing business to be ongoing after the flooding and until the sale of the property. Hope clearly wanted to continue operating out of the Clinton property following the flooding, as evidenced by the fact that Hope paid Mr. Mitchell $2 million in 2018 to purchase the property without any repair work to Building B having been performed. Even with Building B in its damaged state, Hope considered the property worth $2 million. With this in mind, it is almost certain that Mr. Mitchell could have charged Hope rent to use buildings A and C, albeit at a reduced rate from the original $15,000 a month. The argument that buildings A and C could not be used in a leasing business without Building B is therefore inaccurate. Appellants insist that buildings A and C could not be used without Building B because the main bathrooms and utilities were located in Building B, with only small bathrooms in buildings A and C. However, appellants have not provided floor plans or other documentation supporting their contention that all bathrooms, electrics, communications and data utilities were exclusively located in Building B. Moreover, it is undisputed that Hope continued to occupy buildings A and C, suggesting that it had sufficient access to bathroom facilities. Appellants have not explained how Hope was able to operate out of buildings A and C if it did not have access to bathrooms or utilities. As a result, buildings A, B and C were not one economic unit for purposes of Section 1033. Under the second requirement, the destroyed property must have been involuntarily sold. In C.G. Willis, Inc. versus Commissioner, the tax court stated that there is an involuntary conversion when the taxpayer's property, through some outside force or agency beyond its control, is no longer useful or available to it for its purposes. The taxpayer must be compelled to give up the property. In other words, there cannot be an involuntary conversion when the taxpayer has a choice between keeping the property or selling it. In the case of C.G. Willis, Inc., the taxpayer chose to sell its damaged ship instead of repairing it, despite receiving insurance proceeds covering most of the cost of repair. The tax court held that the taxpayer was not compelled to sell the ship because the ship was repairable, and therefore the sale did not qualify as an involuntary conversion. The tax court noted that the taxpayer may have exercised sound business judgment by selling the ship, but the mere fact that the taxpayer had a choice to make just proved that the sale was not involuntary. In Revenue Ruling 78-377, the taxpayer received insurance proceeds for the damage to a shopping centre that had been partially destroyed, but elected to sell the shopping centre instead of repairing it. The IRS stated that this sale did not qualify for gain deferral under Section 1033 because the destroyed property could have been replaced and the non-destroyed property could be used without the destroyed property. The facts of this appeal are similar to the case of C.G. Willis Inc. and the revenue ruling. Mr. Mitchell owned property that was partially destroyed, and he received insurance proceeds that covered the vast majority of the cost to repair. Mr. Mitchell could have repaired Building B, but instead he chose to sell the entire Clinton property, much like the taxpayer in C.G. Willis Inc. Appellants place much emphasis on the supposed shortfall between the insurance proceeds and the cost to repair the entire building. However, there is no evidence that a shortfall results in an involuntary conversion, as we saw in the C.G. Willis Inc. case. Similarly, the amount of insurance proceeds does not appear determinative to the outcome in the revenue ruling. Regardless, the cost to repair the Clinton property is not known. Appellants submitted a bid showing a repair cost of just under $2 million. They have not proven that any other costs were required beyond this or proven that additional expenditures were necessary. The insurance proceeds were $1.75 million, covering around 88% of the estimated cost to repair. This is remarkably similar to the taxpayer situation in C.G. Willis Inc., where the insurance proceeds may have only covered 87% of the cost of repair. Regardless of the exact ratio of insurance proceeds to cost of repair, the second test states that the taxpayer must be compelled to give up the property due to circumstances beyond its control, and the property must no longer be available for its purpose. Mr. Mitchell was not compelled to sell the entire Clinton property, as opposed to amending the lease or repairing Building B. As with the taxpayer in the case of C.G. Willis Inc., Mr. Mitchell may have exercised sound business judgment by electing to sell the Clinton property, but the mere fact that he had that choice means he cannot be said to have involuntarily disposed of the property. Taxpayers cannot choose to pursue more profitable opportunities elsewhere and also claim the benefit of Section 1033. As such, appellants have not satisfied the second requirement of an involuntary conversion. Under the third requirement of an involuntary conversion, the taxpayer must show that continuation of the business on the non-destroyed property was impractical. Returning to the case of Massa, we can see an example of when continuation of the business on the non-destroyed property was impractical. In Massa, the taxpayer was able to find an alternative parking lot, but it was 1.5 miles away from the main loading zone. The tax court found that operating the business in this manner would have been expensive, dangerous, and harmful to customer relationships, and would have led to traffic management issues in the area. The court stated that the taxpayer would have had to go to extraordinary lengths to continue operating its business, and that even after going to these extraordinary lengths, its operations would have been incredibly inefficient. As such, continuing the business on the non-destroyed property was impractical. Appellant's circumstances are markedly different. Mr. Mitchell's leasing business for the Clinton property seemingly continued automatically after the flooding. Hope continued operating out of buildings A and C. The fact that Mr. Mitchell chose to let Hope lease the building rent-free does not mean that the leasing business did not continue. This is also evidenced by the fact that Mr. Mitchell continued reporting expenses for this leasing business into 2018 on appellant's California tax return. Appellants insist that the test of impracticality under Massa is one of mere economics, and that Mr. Mitchell meets the impracticality test because he could not economically operate the business after the flooding, and that there would be a decrease in profits and operations would become more difficult. That is not how the tax court described impracticality in Massa. Similarly, the IRS in Revenue Ruling 78-377 does not consider the profitability of the taxpayer's business to be important to the issue of impracticality. Appellants have not provided any legal support for the notion that a mere reduction of profitability or an increase in the difficulty of business operations equates to impracticality. In C.G. Willis, Inc., the taxpayer incurred additional costs following the damage to its ship, and business operations were more challenging. However, the tax court held that taxpayers cannot sell a property to pursue a more profitable opportunity elsewhere, and then claim a deferral of the gain under Section 1033. Even assuming that profitability is important to the test of impracticality, there is no evidence that Mr. Mitchell could not have operated the Clinton property at a profit after the flooding. Finally, appellants also argue that continued ownership of the Clinton property was impractical because the Clinton property would only have been worth $3 million after all the repairs. There is no evidence to support this future hypothetical valuation. Hope previously had an option to purchase the Clinton property for $3.3 million. However, that had already expired. It also did not include work done to bring the property up to modern building codes. A repaired and enhanced Clinton property would therefore presumably have been worth well in excess of $3 million. Regardless, the test is that continued ownership of the entire property must be impractical. The test is not whether repairing the damaged portion of the property would generate a profit. As discussed, buildings A and C were available for use even without building B being repaired. As such, continued ownership of the Clinton property was clearly not impractical. To conclude, there are 4 requirements for an involuntary conversion where non-destroyed property is sold alongside destroyed property. All 4 requirements must be satisfied. The failure to satisfy any one of these requirements means that appellants cannot claim a deferral of gain under Section 1033. Appellant's sale of the Clinton property and subsequent purchase of the Garden Road property fail to satisfy 3 of the 4 requirements for an involuntary conversion where non-destroyed property is sold alongside destroyed property. As such, appellants have failed to satisfy their burden of proof and do not qualify for gain deferral under Section 1033. That is the end of my presentation. I would be happy to take any questions you may have. Thank you.
All right, thank you, FTB. With that, I'm going to turn to my co-panelists and see if we have any questions for you. I'm going to begin with Hearing Officer Elsom.
Hi, I just had one question. Appellant had dropped the option price for the sale of the Clinton property from $3.3 million to $2 million to account in part for this damage, and stated the insurance proceeds were not paid out for 15 months, and then there was problems obtaining a second loan, different hurdles associated with that, and that even if they had, that a cash flow shortage would have occurred. So my question is just with FTB, maybe at the audit level or at some point during this process, did FTB obtain any analysis or information to show that the appellant could have charged rent at a reduced rate, or is this being pulled from basically the case law that you've cited and the fact that Pods A, I believe only Pod A was rented, according to appellant's testimony, but that Pod A and let's say Pod C had the 3 to 4 employees?
Yes. We believe that, or certainly as we've been discussing in the briefings, that buildings A and C were being used and that hadn't been challenged up until today. But I am not aware of any information in the audit record that talks about what amount of rent could have potentially been charged. We just feel that some rent could have been charged for using 2/3 of a property that was being rented for $15,000 initially. We accept that it wouldn't be the full amount. However, we would assume that building A and C has some value to Hope, and we think it has value to Hope because, they bought it, so they clearly saw some value in operating out of it.
Okay. Thank you. No further questions.
Judge Hosey, do you have any questions?
No questions from me. Thank you for your presentation.
All right, FTB, I've got one question for you. I want to clarify my understanding of FTB's position about the Willis case. It sounds like you're saying the fact that property is repairable after a fire, flood, anything of that nature, means that the sale of it is not going to qualify for an involuntary conversion if the property is repairable. Is that correct?
Yes, I believe that's correct. I think to an example maybe of when, if the property is condemned, for example, or something like that, then we would see an involuntary conversion. But I would say if it's repairable, then yes, there's no involuntary conversion.
I'd like to ask if there's any sort of limits on that argument, because involuntary conversion isn't necessarily going to always be a condemnation or use of eminent domain. It can be other things like flood in this instance. In the case where repair costs were astronomical, is there a limit to FTB's position about the cost to repair being required to be sort of done before you can do an involuntary conversion?
Perhaps. I'm not sure how I'd want to get into the hypothetical. All the cases that I have seen are always about condemnations. So it's very difficult to say when that limit then might be, if the costs were so astronomical. I suppose it's possible, but I think it would be a bit of a hypothetical. I struggle to answer that one.
All right, I understand. Thank you, FTB. With that, I believe we're going to go ahead and take a 10-minute break before we get to appellant's rebuttal. So the time is 2:24. We will reconvene at, let's say, 2:35. All right, we are just about ready to get started. We are going to resume the record. Let's see. Mr. Magnus, are you ready to begin your rebuttal, your closing statement?
I am.
All right, please begin when you're ready.
I'd like to begin where the Franchise Tax Board left off. And let's go back to Masser and take a look at what that case really stood for. It started with a statement that taxation is eminently practical. And when we are looking at relief provisions such as 1033, we're supposed to liberally apply them as opposed to deductions where it's a strict construction. So that's the premise where we start, and that's where Masser started. Masser also says that when you're looking at whether or not the reconstruction or repair of damaged property is economic, you have to take into consideration the taxpayer's sound business judgment. So if you ignore that, then what you've done is you've basically gone to a strict construction, which flies in the face of what the U.S. Supreme Court said in Tyler versus the United States, which says that taxation is eminently practical. Now, there's a continuum of the law on 1033. The Franchise Tax Board is ignoring the continuum. So you have a case such as C.G. Willits, where you have one item of property that is damaged. You then have the next level of the continuum, where you have, let's say, Revenue Ruling 77-377 or 78-377 that was quoted by the Franchise Tax Board, where you have one piece of property that is partially damaged or destroyed, and is it possible to use what's left, excising what was damaged? And then you have the cases such as Masser, where you have two totally separate properties, two totally legal separate parcels, but happen to be used in the same business. And that's where the Franchise Tax Board is living its argument that we happen to have multiple separate pieces of property, if you will, and they're arguing that whether you call them pods, separate buildings, separate whatever, you have one parcel of interconnected pieces of construction that only work together as one. But let's go into what the law says as to each level of the continuum. So let's go to C.G. Willits. So what were the facts in C.G. Willits? In C.G. Willits, the analysis said that, or the facts said that the ship could be reconstructed or repaired for between $100,500 and $120,000. And the evidence also showed that the taxpayer received $138,870 in insurance proceeds. So in that case, they received more than sufficient cash to do the reconstruction. Now, the Franchise Tax Board is arguing, well, they only received 87% of what it actually cost. But what did the case said? It said that where the restoration of damaged property to its pre-loss usefulness for the taxpayer's intended business purpose is not economic, the post-casualty sale of that partially damaged property is involuntary. So where is it along that continuum where it becomes uneconomic? Well, you have to take into consideration the taxpayer's position. It's one thing if I am Bill Gates and I've got $3 billion I can throw at a problem, and it's another thing if I'm Robert Mitchell and I don't have enough cash to reconstruct, to do the reconstruction. So if you treat this building as one building, this one legal parcel, one address, one lease, one set of utilities, all of the utilities going into the portion of the building that was damaged. If you treat it as one, was it economic, having received less money, and depending on which bids you're looking at, were between 250 and $1 million plus, and that's using one-year-old comps, one-year-old bids. So we knew it was going to be significantly more, and where you don't have the money and you go talk to your banker and the banker won't lend you the money, then by definition it's impracticable, it's uneconomic to undertake the reconstruction, and therefore the sale, under the C.G. Willits analysis, is involuntary. Let's continue on the continuum. So 78-377 involved a shopping center. And in that shopping center, you had a fire that partially damaged it. That shopping center had multiple leases with multiple different tenants, and it was admitted in evidence that that shopping center could continue operational if you excised the portion that was burned. And it also showed that it could operate at a profit if you excised the portion that was burned. Contrary-wise here, we have one project, and whether you call them 3 buildings, one building with 3 wings, 3 separate pods, they were interconnected. The property that was damaged, the centerpiece, is where all of the utilities came in. If you excise that piece, you have no utilities for A and C. Now, the Franchise Tax Board tries to make a big deal out of the fact that the lease continued and the Hope continued to occupy buildings A and C. Well, that's a little overstepping what the testimony is. And the testimony is that you had 3 employees of Hope occupying one room in Building A, and the only way they could occupy that is because Building C or B had yet to be demolished. They had yet to cut the power so they could either reconstruct or repair the facility. And they did so at no rent. So it's not like they were occupying a 10,000 square foot building or the whole 33,000 square feet of the building. They were operating out of one office that happened to have a toilet that would allow the 3 people to occupy it. And the evidence is even more startling that when the HVAC systems were stolen, the only way they were able to occupy it is by putting in essentially a window unit where they vented out through the original HVAC's ducting. I mean, talk about a hoopty, right? I mean, it's not like you could go out and lease this facility in that condition to third parties for any amount of rent. So what does the taxpayer have to show under Revenue Ruling 78-377? The taxpayer must show that the property sold could not practically have been used without the replacement of the damaged property. Clearly, this property could not have been used without the repair and reconstruction of Building B. As soon as that work started, nobody could be there. There would be no power. There would be no water. Not until that work was completed. And the evidence shows that the cost of that work was more than the insurance proceeds and more than my client had. And therefore, using sound business judgment, which is going right back to Masser where we started, he determined that he had to sell the project and rolled that money into like replacement property. So, Masser. Again, this is starting with the assumption that I have multiple different parcels that could be legally separated off and sold as separate parcels. We don't have that here. We have one parcel, one address, one access to the roof, one shared bathroom, one shared set of utilities, one meter for electricity, for water. And therefore, once that central portion into which all of those utilities came is destroyed, the rest of the project is not usable. And going then back into Masser, we have to show that it's impracticable to rebuild. The actual wording was that we have to determine, with the exercise of good business judgment, that you can economically operate in the after condition. We couldn't do that here. And therefore, even under Masser, if we assumed that we had multiple different parcels, we would still qualify as the decision to sell after the loss once you determined what it would cost to rebuild. And, you know, there is a timing delay, right? Whenever you have a loss, the insurance company is going to come in. They have to adjust the loss. Where there's a disagreement between the taxpayer and the insurer, as was the case here, you're going to have to continue to have negotiations between the insurer and the insured to determine how much would ultimately be paid. Unfortunately, we were in a time where there was great inflation. The costs of construction were going up. The bids that were received to do the repair in June of 2017 were obsolete by the time we received the money to do that repair. And even if I used the bids from a year earlier, the money we received was insufficient to do the job. Did Hope now see economic usefulness in the property? Yes. But their economic use of it is irrelevant. What their sources of funding are, what the purpose to which they were going to put the building is irrelevant, because in every one of these 1033 cases, somebody is buying the damaged property. You always have a buyer. Now, if it's a condemnation, it's a government agency that's buying it. They see usefulness to it in some way. Or it's a private buyer. That private buyer has a different set of economics than the seller. But for the purposes of today, whether or not this exchange qualifies under 1033 for deferral. We aren't avoiding income tax. We're just deferring when it's recognized and when the tax is paid. You look at the economic situation of the taxpayer, and the evidence shows that it was uneconomic to repair and replace the center portion of this building, Pod B, Building B, however you want to label it. It could not be done by my client and make this still an economic viable business. You have to, in all tax cases, I've never seen a tax case argued where it doesn't matter whether you make a profit or not. The only time I've ever seen that is when we're doing hobby losses. And the IRS comes in and says, you're only losing money, and therefore it's not a real business, and therefore you can't take the deductions. This isn't that. We have a piece of real estate that was leased, that was purchased to make money. That was the purpose of it. And in the end, we suffered a casualty loss that basically precluded my client from making money with that project. Whether the buyer can make money on it or fulfill their charitable purpose, that's great. But for the taxpayer, it was uneconomic and he had to sell. The sale was directly tied to the involuntary loss, the casualty loss, and therefore the findings of the Franchise Tax Board should be overturned, and the only decision, in my opinion, and I'm being humble because it's your opinion that counts, is that this was an involuntary conversion. The 1033 exchange should be allowed, and the Franchise Tax Board will have ample time, if and when my client sells, to recover whatever gain was realized but not recognized in this transaction. And with that, I will rest.
All right. Thank you for your presentation. I do have one question, just to confirm for the record. I want to make sure I understand, and this question is actually regarding the witness testimony. I want to understand if there was electrical for Building B after the loss. I recall, I apologize, electrical for Building A, where the Hope tenants occupied, because my understanding is that Building B contained the electrical components, but they were able to operate a window air conditioning unit in Building A.
Yes.
Yes. So they stripped a lot of the stuff off B. The utility was still there, but if I had to come and demo it, along with the bathrooms and everything else like that, but there was enough over there, but all the air conditioning was out, but they had enough conduit coming over because they stripped a lot of the stuff in between. The question, as being stated, is once I demoed it, there would be no electricity available. But large portion of everything else had no electricity because the conduit or the wires were removed.
All right, thank you. I just wanted to confirm.
Yes.
And then I have one question for Mr. Magnus. During FTB's presentation, they said that appellant's returns showed that expenses related to the Kirlington property were reported, and that showed that the leasing business was ongoing after the flooding. Would you like to respond to that argument of FTB's?
The taxpayer is required to report all of their expenses, and the evidence shows that once the loss incurred, the expenses of the ownership and operation of the business continued. Right? You have to maintain that property. You have to keep the landscaping up. You have to keep the premises clean. You have to make sure that the utilities are paid, the property taxes are paid, and the mortgage is paid. And the taxpayer is required to report all of those expenses. It also shows they didn't have any revenue. They had no income at that point in time. And so their expenses associated with that rental property would not have terminated until it was sold.
All right, thank you. That concludes my questions. I'm going to turn to my panelists for other questions. Hearing Officer Ellison, do you have any questions for either party?
I have no additional questions. Thank you.
Thank you.
All right, Judge Hosey, do you have any questions for either party?
No questions from me. Thank you.
Thank you.
All right, with that, do we have any questions from either party before we close the record? All right, I'm seeing shaking heads. So with that, this case is submitted on October 7th at 2:53 p.m. The record is now closed. I want to thank everyone for participating today. The judges will meet to deliberate and decide your case. We will issue a written opinion within 100 days. Today's hearing in the appeal of Mitchell is now concluded, and that concludes our hearing calendar for today. Thank you.
Thank you so much.
Thank you so much. Oh, I broke my wrist. Exactly, exactly. I had to tell them twice, yeah.